Hello everyone. Today's class is about the winding up of a company. Winding up of a company is a process through which the life of the company comes to an end and its property is administered for the benefit of its members and creditors. We know that company is an artificial person created by law and the ending also is by the law. That's what we have to discuss in this topic. For the winding up proceedings or in the winding up proceedings that an administrator called a liquidator is appointed and he takes the control of the company, collects its assets, pays its debts and finally distribute any surplus among the members in accordance with their rights. The modes of winding up of a company. There are two modes of winding up of a company. As per the Companies Act, the procedure for the winding up of the company can be initiated either by the tribunal or by voluntary. There is two methods. The first method, that is the winding up by the tribunal. A company can be wound up by the tribunal in the circumstances, that is, 1. When the company is unable to pay its debts. 2. If the company has by special resolution resolved that the company be wound up by the tribunal. And 3. If the company has acted against the interest of the integrity or morality of India, security of the state, or has spoiled any kind of friendly relationship with foreign or neighboring countries. 4. If the company has not filed its financial statements or annual returns for preceding 5 consecutive financial years. If the tribunal and 5. If the tribunal by any means finds that it is just and equitable that the company should be wound up. And 6. The company in any way is indulged in fraudulent activities or any other unlawful business or any person or management connected with the formation of the company is found guilty of fraud or any kind of misconduct. In all these circumstances, the company can be wound up by the tribunal. Filing of winding up petition. That is section 272 provides that the winding up petition is to be filed in a prescribed form. The petition for compulsory winding up can be presented by or can be filed by the persons are the company, the creditors, any contributory or contributories, by the central or state government, or by the registrar of any person authorized by central government for all that purpose. The powers of the tribunal. Tribunal, after hearing the petition, has the power to dismiss it. That means petition for winding up has to dismiss it or to make an interim order as it think appropriate, or it can appoint a provisional liquidator of the company till the passing of the winding up order. The effect of winding up by the tribunal. Section 278. According to this section, the order of winding up of a company shall operate in favor of all creditors and all contributories of the companies as if it had been made out to the joint petition of creditors and contributories. In fact, it shall operate in favor of all creditors and all contributories of the companies. The winding up procedures. The final order. That is, according to section 282, the tribunal, on consideration of the report of the company liquidator, fix a time limit and within which the entire proceeding shall be completed and the company be dissolved. And the court will also order for the sale of the company as a going concern or its assets on examination of the report, and can also appoint a sale committee for consisting of creditors, promoters and officers of the company to assist a company liquidator in the sale. That means sometimes the sale become a problem. At that time the court can appoint a sale committee. And next, if the report discloses that a fraud has been committed in the company, then the tribunal will order for investigation or direct the company liquidator to file a criminal complaint. And If the tribunal will also take necessary steps to protect, preserve, and enhance the value of the assets of the company. And after these proceedings, the dissolution of company by the tribunal, that is section 302. When the affairs of the company has been completely wound up, that means after completing all these proceedings, the affairs of the company has been completely wound up, the company liquidator shall make an application to the tribunal for dissolution of such company. That means to the full ending of that company. Winding up procedure will start, and last the company cease to exist. That's the dissolution. And then the liquidator shall make an application to the tribunal for dissolution of such company. Next is the second category, that is the voluntary winding up of a company. That is, first is the winding up by the tribunal, and second is the voluntary winding up. And in this topic, the company can be wound up voluntarily by the mutual decision of the members of the company. There are certain situations the company will take a decision to wound up voluntarily. That is, in case the company passes a special resolution stating about the winding up of the company. Secondly, the company in its general meeting passes a resolution for winding up as a result of the expiry of the period of its duration as fixed by its articles of association, or at the occurrence of any such event where the articles provide for dissolution of the company. That means the articles specifies that the winding up of a company a specific period of time, or certain event, occurrence of certain event, the company has to be wound up. Then the company can pass a resolution for winding up. And next, the important thing regarding the voluntary winding up of this, that section 304 and the provisions related to the voluntary winding up of the company were omitted in 2016 Act. Now, the Insolvency and Bankruptcy Code 2016 deals with the voluntary winding up process. That means the company in the Companies Act, section 304, and the provisions relating to the voluntary winding up of a company were omitted in 2016 Act. And now it is dealt under the Insolvency and Bankruptcy Code. That is, the voluntary winding up proceedings were now in according to the Insolvency and Bankruptcy Code 2016. The effect of voluntary winding up. In case of voluntary winding up proceedings, the company shall, from the commencement of the winding up, cease to carry on its business except as far as required for the beneficial winding up of its business. That is, the corporate, state, and corporate power of the company shall continue until it dissolved. But the beneficial winding up procedures will continue for the company. Procedure for voluntary winding up. Conduct a board meeting with the two directors and thereby pass a resolution with a declaration given by the directors that they are of the opinion that the company has no debt or it will be able to pay its debt after utilizing all the proceeds from the sale of its assets, and then issue notices in writing for calling of a general meeting proposing the resolution along with the explanatory statement. Next, in general meeting pass the ordinary resolution for the purpose of winding up by ordinary majority or special resolution by 3/4 majority. The winding up shall be started from the date of passing of the resolution. And then conduct a meeting of the creditors after passing the resolution. If the creditors are of the opinion that winding up of the company is beneficial for all the parties, then the company can wound up voluntarily. And then within 10 days of passing of the resolution, file a notice with the registrar for appointment of a liquidator. And within 14 days of passing such resolution, give a notice of the resolution in the official gazette and also advertise in the newspaper. And within 30 days of the general meeting, file a certified copies of ordinary or special resolution passed in the general meeting. Then wind up the affairs of the company and prepare the liquidator's account and get the same audited. Then conduct a general body meeting of the company, last meeting. In that meeting, pass a special resolution for disposal of books and all other necessary documents of the company when the affairs of the company are totally wound up and it is about to dissolve. And within 15 days of final general meeting of the company, submit a copy of accounts and file an application to the tribunal for passing an order for dissolution. If the tribunal is of the opinion that the accounts are in order and all the necessary complaints have been fulfilled, the tribunal shall pass an order for dissolving the company within 60 days of receiving such application. Then the appointed liquidator will then file a copy of order with the registrar. Registrar, after receiving the order passed by the tribunal, then publish a notice in the official gazette declaring that the company is dissolved. That is, after receiving the order passed by the tribunal, the registrar then publish a notice in the official gazette declaring that the company is dissolved. This is the process of winding up of the company by the tribunal and by voluntary winding up. Thank you.